that go into creating our system of laws, and what were the main bodies of law that we talked about in the last class? Who remembers that? The main body of law. What were the main bodies of law?
Constitutional.
Constitutional law, right? And that was made by what?
Federal government.
The federal government. And what other government has a constitution? What other government has a constitution? State, right?
Yeah.
You have a state constitution, you have a federal constitution, right? And underneath the constitution is what else? Statutory law. And what is a statutory law?
Laws enacted by legislative bodies at any level of government, such as statutes passed by Congress or by state legislatures, make up the body of law known as statutory law.
Exactly. And so underneath and within the idea, or within the realm of statutory law, are three main bodies of law. What are they?
Administrative law.
Well, administrative law is kind of a separate idea because administrative law comes out of statutes. You're right, but administrative law is administered through a separate proceeding, which we're going to talk a little bit about, and governed by what they call the Administrative Proceeding Act of the APA. And there are APA, similar APA, which is a federal statute applied even in the state law that gives your kind of rules for governing administrative procedures. But what are the other elements that fall under statutory law?
Ordinances, uniform laws, uniform commercial code.
Exactly. Exactly. All right. So in the context of, but going to administrative law, what can you tell me about administrative law? What can you tell me about administrative law, Mr. Calloway? Thank you. Mr. Calloway.
Administrative law, the rules, orders, and decisions of federal, state, and local government administrative agencies.
And what are those rules? What keeps us from just basically having administrative decisions being issued arbitrarily and capriciously? Ms. Hall, what do you think?
Regulations govern business capital structure and finances, hiring and firing procedures, its relationship with employees and unions, and the way it manufactures and markets its products.
Okay, so my question is what is the kind of area or what is the body that the body of law or the body of rules, quite frankly, really we're talking about the rules. What rules go into preventing administrative agencies from issuing decisions arbitrarily and capriciously? So, in the book, for example, they talk about the rules issued. It says rules issued by various administrative agencies now affect most every aspect of the business operation, right? The regulations, these regulations that you said govern a business capital structure. But the issue is, as I mentioned to you earlier, it's not included here. But as I said, there's something that's similar to what we discussed in the last class called the Rules of Civil Procedure, which governs the way in which courts operate, that is similar in the context of administrative agency decisions. And administrative agency decisions are not necessarily governed by the Rules of Civil Procedure, but more so governed by the Administrative Procedure Act. And the Administrative Procedure Act is a federal statute, but most states have incorporated that into their own state laws as well. So that's the key thing that I wanted to talk to you about that. All right. The other key issues, we talked a little bit about it in the last class, but I want to just make sure that we understand the distinctions between these kind of key areas. The courts of equity versus courts of law. And the issues of the difference between you guys have to see, I'm sorry. The difference between the equity and law, courts of law, Mr. Copeland, is what?
Courts of equity is a branch of law founded on notions of justice and fair dealing that seeks to supply remedy when no adequate remedy at law is available. And the courts of law, is the system made the procedure for settling disputes more uniform. When a complaining party wanted a remedy other than economic compensation, how the courts of law could do nothing, so it was really no right.
All right, excellent. So again, we're talking about, as we said before, the courts of law are those that are generally going to give you what kind of damage, Mr. Copeland? What kind of damages are going to come out of, what kind of results? What is the court going to issue in the context of courts of law? Monetary, absolutely. In the context of equity, what are they going to give you?
They're going to give you sharing of the damages.
Damages, or what type of decisions are they going to issue?
I think petition to call it taxable.
Again, it's in Exhibit 1.3 or 1.3. The remedy that is going to come out of equitable actions are going to be what?
Adequate remedy.
The remedies are going to be what, Miss Green? Thank you.
Injustice,
Pardon me?
injunction,
Injunctions? What? What else?
specific performance and rescission.
Exactly. And what is rescission?
Excuse me?
What is rescission? This was in chapter dealing with contracts. You remember it? What is rescission?
Google it.
Mr. Copeland, can you help her? Rescission. Miss City Hall, help her out. What is rescission?
A remedy whereby a contract is canceled and the party are returned to the position they occupied before the contract was made.
Occupied, right? So that's the key thing. The remedies at law specifically is going to give you a monetary damage. That's really what a court of law will provide you, or an action at law. An action in equity, which is also going to be before court, they're going to give you specific performance, which might be injunctive relief, or maybe rescission, right? Which is, again, rewriting the law, putting the contract and putting the parties back into the position they were when they first started. Okay, those are the key things that we wanted to review there. All right, you can have a seat. Since Ms. Hall, you didn't get a chance to really chime in, let me ask you this then, Sydney Hall. Tell me about the issue or the theory of stare, or the doctrine of stare decisis. Stare decisis. And so, stare decisis, is it an English word? All right. So, what does it mean? And what does it mean?
Under the following doctrine, judges are obligated.
Hold on, I was asking you, what does the word stare decisis mean?
Stand on decided cases.
Stand on decided cases. So, what is that? How does that play into the context of our legal system? One of the most fundamental elements of our legal system, the context of courts. So what does that mean? What does that mean? Thank you. Looking for a marker here. Pardon me? You hit it right on the head. So the way in which this system of laws is set up here in the United States is that we talked about the three types of law, right? What was the first type we talked about? Let's start with a C, Ms. Hall. What was it, Ms. Hall? No. The source of law, we said in the beginning. Help her out. What was it? The Constitution, right? The second was what? Statutory law. The third area is what they call, again, the court. Court decisions. Court decision. Now, a court decision is, when a court decision is rendered, that becomes law. Now, some theorists suggest that courts are not supposed to issue law. Their job is to do what, Ms. Hall? Ms. Hodge, what do people say that courts are supposed to do? What are the roles of courts?
To make a decision.
To make a decision, right? they're here to make a decision. So what are they doing in the context of law?
Like what they call return
Yes, they're making a ruling, right? But in the context, are they making laws?
No.
What are they doing? They're supposed to be doing. Well, they're really enforcing actually comes next. But really they're, in the context of the conversation, they're interpreting what laws are. They're determining whether or not, for example, if you said, I have a contract, the contract is in violation of the law, I want a remedy, they look at the contract and they say, yes, either you're right or you're wrong. They look at the law and they interpret what the law means, right? And how it's applied to a specific set of facts. However, in actually making their ruling in and of itself becomes what, Ms. Hall? Their orders become what? Their orders become law also. And as you said, the reason why is because of the doctrine of what, Ms. Hall? Stare decisis. Because each legal decision, right, basically, this marker was a little bit dry. Each legal decision, anyway, can you let's see if there's another marker in the classroom. Each legal decision actually, again, creates a foundation for the others. So if you have, let's say, for example, so again, what happens is that this, for example, here, the court, if there's no other precedent in this area, the courts will basically consider this case a case of first impression. And what that means is that no other court has considered it. And so then what they look to for guidance in rendering a decision are the other authorities. The other authorities can be, again, cases from similar jurisdictions. They can be legal principles. They can be policies, fairness, and social, as well as social factors, right? All of these are, again, brought into play in the context of rendering a decision. And once it renders a decision, then now you have a decision. And every other court in that, every other judge who sits in that particular court is obligated to do what, Ms. Hall? Ms. Hodge? Thank you. Exactly. They're obligated to basically render decisions based upon the decision that was rendered before. That's the idea of precedent. Stare decisis, okay? Very key thing. So by doing that, they actually are creating law, right? Just as, again, the state legislatures created the law, the courts are also creating the law. Is there, for example, Ms. King, is there a law? Is there a law that was passed by the federal government that that allowed same-sex individuals to be able to file joint taxes? Are you familiar with any law that was passed?
No,
The federal government?
I know the one for they were able to get married. I don't know about the taxes.
No. But in fact, even in the context of, again, you said the ability for them to marry. On the federal government, the federal level, there was no law passed to say that there was a right for same-sex individuals to marry. However, courts rendered decisions. The Supreme Court in particular rendered a decision that, again, established that practice as being lawful. So again, in this context, where the federal government did not, again, weigh in, the federal courts, particularly Supreme Court, has intervened. And that's, again, one example. Another example is the issue of the travel ban, right? We know that the federal government, particularly with respect to the Department of Homeland Security, through the president himself, issued an executive order. That becomes law. However, what happened, Ms. Hodge? People took him to court, right? And because they took him to court, what did the court say? They couldn't do it. And they said they couldn't do it because of what, Ms. King? And saying they couldn't do it, what does that mean?
What does it mean?
Yes.
Are you saying it's illegal or something?
Yes. The court said that based upon what, again, the law, and again, it's going back to interpreting. It said based upon what the fundamental, again, laws that we have, particularly in the Constitution, that this order is in contravention with what amendment of the Constitution in particular? Does anybody remember? What, did you guys, did anybody do the homework?
What law are we talking about?
I said,
It's
which
the one with six.
amendment?
For what law are we talking about?
We're talking about the context of the recently issued executive order prohibiting certain people from being able to come to the country.
The 14th?
It was the 14th Amendment? Which amendment was it? Was
The
it the 13th Amendment? What was the 13th
is
Amendment? Who said that?
Slavery. That's abolishing slavery.
Which amendment was it? Who submitted the homework?
I did.
Who did? So which amendment was it? Mr. Parks? Huh?
I'm asking you what you said.
I said, which amendment did the court find the travel ban violated?
Oh, the travel ban.
The idea of selectively targeting various individuals based upon their religious belief from coming into the country. What did they say that violated? Which amendment? Which amendment? The First Amendment. Hopefully, once you guys all finish the homework, you'll be able to understand which amendments go to what, right? So that's the idea of what courts do and why they're so powerful, right? So now let's take a look at the basic steps of briefing a case, all right? So you guys can have a seat. The context of briefing a case, what you want to look at is what they call, they use as a format, the IRAC. IRAC. What does IRAC stand for?
Issue, rule, application, conclusion.
Who was that? Ms. Samay? You can stand up. Ms. Samay? You said what?
It's the issue, rule, application, and conclusion.
Okay, well, tell me, what's the issue? As the great law professor, many of my colleagues out there who might remember Professor Patricia Squire. She used to ask, what's the issue? What is the issue? A great legal scholar from Florida who taught us at Howard Law. What is the issue? And so in this context, what is the issue, Ms. Samay?
What are the key facts and issues? Suppose that a plaintiff comes before the court saying that words or acts that wrongfully and intentionally make another person fearful or immediate physical harm.
So again, the point is, what are the facts and the legal questions? When you say issue, you were really looking for what are the legal questions, right? That's the I. Next is the R. What does the R stand for?
What rules of law apply to the case?
And when you talk about rules, what are we talking about there?
A rule of law may be a rule stated by the courts in previous decisions, a state or federal statute, or a state or federal administrative agency regulation.
Exactly. So we're talking about now you have the facts, right? You have the questions, then you have the laws, and then the A. What is the A?
How do the rules of law apply to the particular facts and circumstances of this case?
So again, now they're going to talk about the analysis. Some, in fact, substitute the word application to analysis. And they take a look at the facts, then they look at the laws, and then they have a discussion. Does this particular law, like going back to the travel ban, right? Does the First Amendment allow or prohibit the executive branch from singling out certain countries that just so happen to be of a particular religious belief and exclude them from coming into the country, right? And then the C is what?
Conclusion. What conclusion should be drawn?
And then they make a ruling. They say either, well, the new travel ban also identifies other countries who are not of that same religious belief, right? And then they say, okay, well, because of that, then maybe the law, maybe the executive order is lawful. Or they say, no. This addition of countries that are not, again, of this particular religious belief are just put in to become a pretext, right? And this is nothing but an illusion that's done to essentially throw people's concern away from what is actually happening, and that is to keep a certain group of people out of the country. So that's the whole idea of, again, the issue, rules, analysis, and conclusion in IRAC. And that is the format by which you will, again, use to brief your case, all right? Thank you. Have a seat, please. Submit. So, Mr. Oshiraboy, tell me now, how do you read a decision? Okay. All right. How do you read, first of all, how do you find a decision that was issued, Mr. Parks? How do you find? First of all, how do you find what we talked about, the Constitution? Where's the Constitution found? Where the Constitution? Where's the U.S. Constitution found?
I think so.
Where can you find the U.S. Constitution? Well, if you did the homework, where did you find the Constitution? What? Mr. Thomas, where can you find the U.S. Constitution? Who publishes the U.S. Constitution?
That's not your question.
If it's a federal law, whose responsibility is to publish the U.S. Constitution? Is it the state government's? Whose responsibility is it then, Mr. Parks? The federal government, right? So generally, the body, what are the various branches of government?
Executive, legislative, and judicial.
And judicial, absolutely. Which branch of government do you think would be responsible for publishing the U.S. Constitution?
The
the legislative, right? Because those are the people who came up, the legislators, in that context, the framers of this Constitution, before we had our government structure. These members of the Constitutional Convention, they came up with so they were the legislatures in that context. They published the U.S. Constitution. So that's the legislative branch that, again, is responsible for publishing the U.S. Constitution. So where can you now find the next body of law in the federal context, Mr. Thomas? What is it called, first of all? What is it called? What is it called? What is the body of law that is again created by the federal government called? What is it called? What is the kind of the body, the book? What is that called?
The United States Code?
The United States Code, absolutely. And where is that published? Or where can you find that? Who publishes it? Which legislative branch?
Federal? Oh,
Right.
Oh, which branch?
Yep.
Legislative?
Exactly. I'm sorry, I said which legislative branch. Which branch of the government? I gave you the answer to that. Absolutely. And in particular, they say that the www.gpo, right, which is the government printing office, can be accessed in order to find a copy. The Library of Congress also keeps a copy, right? And so those are the things that you can look to in order to find copies of the code. How about administrative rulings, Mr. Parks?
What about, you said how about them?
Yeah, where can they be found? Like the United States Code, what publication can you find those in?
The Code of Federal Regulation.
Exactly, the CFR. And the CFR, again, is divided into 50 titles, and they provide, again, the rules that each agency in the United States government operates within. Every rule that is promulgated by each federal agency is obligated to go into the Federal Registry. Also, again, events or contracts that come out sometimes are also published, or notices of contracts are also published in the Federal Registry. Thank you. Now let's go to the, again, citation. Mr. Tucker, tell me about, you guys have a seat. Tell me about how do you read a citation?
Okay.
What's the first in a citation? What's the first thing you're going to see?
After appellate, I sit and have appellate, so I normally refer to society.
No, so I said the question is, in a citation, what are the first things you're going to see?
Name.
Names of what?
Name of the case.
And the case names are going to give you what?
The volume name and page number.
No, I said the case names are going to give you what? The name that's up here, who are those?
I was gonna give you the legal citation.
I said the name right here. What are these right here?
The organization.
The plaintiff.
Or the plaintiff.
Mr. Willis.
He's in now.
What are those?
The names, the plaintiff and defendant.
Are these the plaintiff and defendant?
These are names of people involved in the case. It's just,
These are these the plaintiff and defendant?
basically, yes, the company.
Is absolutely incorrect. What did we talk about in the last class? What is this name? Oh, how do we know this is the plaintiff? Huh? Is this a trial decision or is this an appellate decision? An appellate, absolutely. And so, in the context of the absolutely, we've been talking about petitioners. And the second party is a what?
I cannot.
The respondent.
I can.
All right? Second is the respondent.
What? What?
Tell me now about this particular case.